Okay, welcome to today's class. Before going into today's topic, a few of the people were asking how to answer a UPSC question. If we don't know the question, how to fill up the gap, or if you know a lot of things, how to squeeze everything and put it in the given space. Okay, so we will have that special answer writing session on Sunday, because Sunday everybody would be free, right? So Sunday we will have it. This Sunday we will be having it, and I'll post the time for the same. Now let's start with our class. Today's topic, we are going to see offense against human body. If you see, there are a lot of offenses against human body. Let me give you a few examples. Wrongful restrainment, wrongful confinement, kidnap and abduction, criminal force, assault, grievous hurt and hurt. Then we have culpable homicide and murder, and causing death by rash and negligence, then miscarriage, thug, and unnatural offenses. If you look keenly, we have skipped certain offenses like rape and other offenses relating to women, because we will be dealing with that in the separate heading called offenses against women. For time being, you have to know how important is this chapter, entire chapter, offense against human body. So let me put you the previous year question analysis. This is the PDF freely available in our website and also in the app. So if you don't have access to this, please inquire in the masterclass group so we can send you the link. Okay. So if you check on, there have been a question 2022, 2021 means. Every year there is a question. So if you skip this topic, almost you lose minimum of 10 marks, because there are times where even 2 questions are asked from offense against human body. But for today's class, we are going to concentrate only on culpable homicide and murder. Why I picked this first is very simple. Just read the questions. Let me point out. Okay. 2022, we have got a question from acid attack. This is a famous question, case law for acid attack. So there was a question on that. 2021, grave and sudden provocation. It is from murder, exception to murder. Okay, one of the exceptions. And then you see 2020, definition of murder. So a question from murder is there. 2019, every culpable homicide and murder is necessarily a hurt. So you see culpable homicide and murder and coupling with other offenses. So my point is very clear. That is, there are quite a lot of chances that you get questions from culpable homicide and murder. So if you're not knowing this particular topic, it is even more serious that there are a lot of chances that you lose a lot of marks. Okay. So reading IPC without knowing this topic is not fruitful. So let's dive into our topic today. 1 minute, let me resize the window so it will not affect the view of the slides. Okay, so offense against human body, starting with homicides. What do you mean by homicide? Let us understand the meaning of homicide with the help of etymology. By bifurcating the words, we try to understand its meaning. What is homi? Homi means humans. Many people know that, right? Homo sapiens. And sido means cut. So homicide means cutting a human, but the meaning of it is killing a human being. So if a human being is killed by a natural calamity or by an animal, can we call it as homicide? We cannot call it as homicide, because the real meaning, the effectual meaning of homicide is killing of a human being by another human being. That's what is called as homicide. Whether mere killing of a human being is punishable, that's the next question. No, always killing a human being is not punishable, which means there is a bifurcation, that is lawful homicide and unlawful homicide. This unlawful homicide is alone punishable. So what are these lawful homicides? They are nothing but our general exceptions. If you're homicide, that is, you're killing a human being for any of the thing that is mentioned under general exceptions, then it is lawful and it attracts no punishment. In lawful homicide, there are two types yet. Okay. One is excusable homicide and other is justifiable homicide. What is excusable homicide? By the per se of the person doing, because of the nature of the person who is doing that homicide, that person is excused. For example, a child committing a murder. Because of infancy, because of the child's immaturity, he is excused. An insane person, for that matter, an intoxicated person, involuntarily intoxicated person. So all these persons, by the per se of their character and immaturity, they are excused. Then what a justifiable homicide? Because of the circumstances, what you do is completely reasonable and justified. So it is a justifiable homicide. Best example is right to private defense. For saving yourself, you push someone, he falls down and he dies. Now you're protected under right to your self-defense and private defense, and it is a lawful homicide. Now let me give you a list of unlawful homicide. First one would be a culpable homicide. See the name per se, culpable homicide, which means punishable homicide, 299. Then you have murder. Then you have, see, we don't have a separate section for the third limb, but this is a third variety, which is called as a culpable homicide, not amounting to murder. Under section 300 itself, we have it. That is nothing but under murder, there are 5 exception situations given. So if you're falling under any one of the exceptions, it is not murder, then it will be culpable homicide, not amounting to murder under section 300. Then you have suicide cases like, abetting suicide, all those things will come in. And then attempt to suicide. Then you have causing death by rash and negligence, which is punishable under 304 capital A. And you have dowry death, 304 capital B. Okay. But for today, we will be dealing only about culpable homicide and murder, which is a very, very crucial section. Others we will deal later. So because you don't get confused. Okay. So let's start our concepts. See, culpable homicide is like a huge family and it is like a genus. Okay. And this murder is a small thing inside this huge family. Say, for example, I am living in Chennai. People of Chennai is like culpable homicide and my family is like murder. So culpable homicide is a bigger arena. If the culpable homicide satisfy certain special characteristic, then only it will become murder. That's why we call culpable homicide is a genus and murder is a species. That is one statement. Important statement. Okay, please note down. And you have the second statement, which can be inferred from this phenomenon. That is, all murders are culpable homicide, but all culpable homicide are not murder. If you see here, all murder are coming within the area of culpable homicide. But all culpable homicide, there is no murder here because only when the culpable homicide is coupled with certain special characters, it will become murder. Why these two statements are given to you? Because UPSC is going to ask statement-based questions. Please note down. Okay. While taking class, you have 2 ideas to do. That is, one, while taking class itself, you can take notes. If at all, you're able to concentrate in class and also take notes quickly. But if you're not able to do that, no worries, just listen because the concepts which is you are gaining is very important. And after that, you can look into the slides and take notes. Okay. So now we are going with the concrete section, that is section 299, which defines culpable homicide. So you have a main clause in 299, and then you have 3 illustrations and 3 explanations. We are going to do even the illustrations because question comes from even illustrations. Let's decipher one by one. Okay. Just I have given you an idea how 299 looks. It has a main clause, 3 illustrations and 3 explanations. Very simple. So what is culpable homicide under section 299? We'll ask someone to read. Abdul sir, can you please help me read this?
Yes, ma'am. Culpable homicide. Whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause, or with the knowledge that he is likely by such act to cause death, commits the offense of culpable homicide.
Okay, thank you, sir. So now let's decipher it into ingredients. You see, culpable homicide defined under section 299. Why again and again I'm pressing on the section? I see people writing 277 sometimes, 300 sometimes. So never make a mistake. Culpable homicide 299. Under this, the death must be caused. Death of the victim must be there, which means the victim must not be alive. And this death must be caused by another person. I told you, right? Homicide means killing of a human being by another human being. So if it is a natural calamity or an animal or something is causing the death, then it is not culpable homicide. And not only this, the death must be caused in either one of these three situations. So the main clause, we are bifurcating into three limbs. So you don't write 299 clause 1. There is no clause 1 in 299. It is first limb, second limb, and third limb. Okay. First limb, you cause the death with the intention of causing death. So you must have the intention while you are causing death. Next, you have an intention to cause only a bodily injury, which is likely to result in death. Very simple. You don't have any intention to cause death, but you have an intention to cause some bodily injury. But this nature of this bodily injury is of such a nature that in some probability, mere probability, it will result in death. Okay. Next, you have the knowledge that your act was likely to cause death. See, we are seeing two terms here. One is intention, another is knowledge. Both are imparting mens rea, mental state of a human being. But what is the difference between these two? Basically, everybody will know, but I'll repeat it. Intention is what is your state of mind, what you aspire from your actions. That is intention. Knowledge is you are aware of something. The state of awareness is called as knowledge. So you don't need to have an intention. You have the knowledge, that is you are aware that your act is going to result in death. Then you are causing culpable homicide. Okay. Now we see few case laws. Before that, we will have a question. Okay, this is a tricky question. That's why I have pointed out here. I'll ask someone to read it. Anurag sir, can you please read this question?
Assaulted his wife by kicking her repeatedly on non-vital parts of her body. She fell down and became unconscious. In order to create an appearance that she had committed suicide, he took up the unconscious body and, thinking it to be a dead body, hung it up by a rope. The postmortem examination showed that death was caused due to hanging. With the help of decided cases, determined the culpability of A.
Hope you understood the facts. Let me try to repeat it. Okay. There was a husband and wife, A, and his wife. Okay. A repeatedly assaulted the wife. And because of this assaulting, she fell unconscious. Immediately, the husband thought that the wife is dead. So in order to escape from the liability, he projected it in such a way that he hung the body of the wife and projected it to be a suicide. Okay. Now, the autopsy report of the medical report of this death is a huge surprise to him because the wife was only unconscious. He thought her to be dead, and while hanging only, she lost her life. So what action led to the death of the person? It is the hanging. Now, whether A is culpable, for we have a lot of offenses against human body, right? So there are hurt, grievous hurt and all, which we can deal later. But for time being, whether A can be committed for murder or any other offenses, that is murder or culpable homicide or for hurt, that is the issue. We see a landmark case. We have three landmark cases. First one, let me tell you, in Emperor versus Dalu Sardar, it was stated that same facts. Okay, even here the husband has hit the wife and she fell unconscious. And once she fell unconscious, he have hung the person. And the same autopsy report told that only by the pressure in the neck, the wife was dead. Now, the court told there is no intention to kill because anybody will intend to kill a dead body? No. right? So there is no intention to kill. There is no culpable homicide when there is no intention to kill. So we can commit him for causing grievous hurt. So give him a rigorous imprisonment for 4 years. That was the dictum. Okay. Now let me give you another case law. You see how the things change. Okay. We have another case, Palani Golandan versus unknown. Here also same thing happened, and the verdict followed from this emperor case and told that it is only grievous hurt. It is not culpable homicide because there is no intention to kill. Nobody will intend to kill a dead body. But here we see a turning point. Sarthi versus state of Madhya Pradesh. Here, the court rightly pointed out, see, someone is unconscious. You are not a medic to say whether someone is alive or he's dead, okay, passed away. Without properly examining or knowing that a person is alive or dead, you are trying to cover up a big thing. So in that case, you are acting recklessly, knowing that if a person is alive, that person is going to be dead by hanging. You know that your action will result in such a probability. Being reckless, you do the same act. So the relevant knowledge is imputed here. So his action falls under the third limb of culpable homicide. Let me explain. Without properly examining whether a person is dead or alive, he knows that his act, that is, he has a knowledge that his act will result in the death of that person. So when this is there, he squarely falls under culpable homicide, third limb, 299. Okay, that was held, and finally this issue was put at rest. Okay. So now let's see the illustrations. Illustrations under, yeah, tell me, ma'am.
Clarify, ma'am. The act the court is talking about is a hanging part, right? Not the assault part.
Yes. Yes, assault part is unconscious, that is different, but he will be punished for that too, causing hurt and grievous hurt. See, every offense, there'll be a cluster of, in FIR, they'll give a cluster of sections for you. Now we are dealing only with this part where the death is caused. Okay, hanging part.
All right, thank you.
Done. So let's go to the 299 illustration. Illustration 1. There is your friend, someone who is digging a pit and he is closing it with the leaves with the intention that you must come inside and fall down and die. This is done with a clear intention of killing you. So this is the first illustration, which squarely is given for which one? The first limb of 299. That is, you kill a person with the intention to cause death. Okay. Now we move on to the second illustration. I know, say for example, there is a person A who is hiding behind the bush. I don't like A. So there is another person B who is ready to hunt everything, and hunting is a hobby earlier, right? During British period. So such an illustration was given. He was ready to hunt everything, something like that. He was ready. So I call B and say that there is an animal behind this bush. So you just shoot the bush. B, believing my words, he gives 2 to 3 shots inside the bush. But unfortunately, there is this person inside A and he falls dead. Now, who is responsible for this culpable homicide? It is not B, because B does not have any intention to kill A. But I was the person who knew that A was hiding and I provoked B to shoot there. So I committed culpable homicide. This is second illustration. Now we go on to the third illustration. Actually, there is a fowl who is hiding behind the bush. Fowl is like a fox. Okay, it is hiding behind the bush. I wanted to go and hunt a few fowls. So I saw it and I shoot it dead. But unfortunately, there is another person who's hiding behind the bush, but I don't know that he is there. So by mistake, I shoot him and he is dead now. This is not culpable homicide because I don't have any intention to kill here. Okay, so why these illustrations are given? Because it is giving you the importance of mens rea for culpable homicide. Now we will go with case laws. Explanation, after explanation, we'll go with case laws. Okay, I told you 299 is having a main clause and then 3 illustrations. We have completed the illustrations. Now going with 3 explanations. First one. Explanation 1, I'll ask Vardha ma'am to read. Vardha ma'am, can you please read this?
Yes, ma'am. A person who causes bodily injury to another who is laboring under a disorder, disease, or bodily infirmity and thereby accelerates the death of that other shall be deemed to have caused his death.
Okay, very simple. A person is giving a injury, bodily injury to a particular person, and this victim is already suffering from some disease or disorder or infirmity. By this bodily injury that the accused is giving, the disease or the disorder is accelerated and finally he dies. Now, the accused cannot say that I just gave a blow and I just gave an injury only because of the disease he died. He cannot take that plea because of this explanation one. The explanation deems that since he is laboring from all these diseases, although you know or you don't know, you give such an injury and his death is accelerated, then you are causing culpable homicide. That is explanation one. But in murder, we will impute a knowledge here again. Okay, we'll see how culpable homicide is escalated to form murder. Now, hope you understood explanation one. Let's go to explanation two. Explanation two says that where a death is caused by a bodily injury, the person who causes such bodily injury shall be deemed to have caused the death, although by resorting to proper remedies and skillful treatment, the death might have been prevented. I give an injury to some person, and he is dead only after 2 hours of that injury. If at all he is taken to hospital in between this time, he must have been alive. Then I cannot say like, come and say in the court and say that, see, I just gave an injury, but later he died only after some time. If at all proper medical care is given, if at all a skillful treatment is given, he must have been alive. So don't punish me for culpable homicide. I cannot take that plea. Although he can be saved by this medicine, although they can be saved by taking into hospital by proper time and all, that has nothing to do with you. If you have an intention to kill and you cause the bodily injury and he is dead, that is enough. So resorting to medical advices and all those things cannot be a plea to escape from culpable homicide. Now we will move on with the third explanation. I'll just explain it, okay? It's very simple. So you're causing death of a fetus inside the womb of the mother, then it is not culpable homicide. When I say it is not culpable homicide, we are not leaving out the person from any culpability. They will be charged under some other offense. They won't be charged under culpable homicide. That's what it means, okay? So you're causing death of a child inside fetus, inside a womb. It is not culpable homicide, provided if a little part of the child's body is outside the womb, that is, even a leg comes out or even a small toe comes out and you cause death of that child, it amounts to culpable homicide. There are a lot of cases where the child will be just born and before it can breathe, because after birth, the child will take some few seconds to breathe, I guess. So in that time limit, in that time interval, if death of that child is caused, it will be culpable homicide. So what is the criteria here? Inside the whole womb as a whole fetus, it is there. You kill it, no culpable homicide. Any part comes out, even though very smallest part it may be, you kill it, it will amount to culpable homicide. That's what explanation 3 gives you. Okay. Now, we are going to the next escalated form of culpable homicide, that is culpable homicide amounting to murder. When culpable homicide will be called as murder, it is given under section 300. 4 clauses are there in section 300 and 4 illustrations are there. And then you have 5 exceptions. Okay. All these exceptions, even the illustrations are very, very important. Each one have been asked as a separate question there. Okay. So let me again tell you how culpable homicide is a family and then this murder is just a species. Okay. There is this culpable homicide defined under section 299. This culpable homicide, if it falls under any one of the 4 clauses that is given under section 300, that is, it has any of the special characters given under these clauses, then only it will turn into murder. That's why we say all murders are culpable homicide, but all culpable homicide are not murder. You get the point, right? So if this statement is given, you have to explain this way. Next, you have to be very, very careful. Yes, culpable homicide satisfying any one of the clauses, it becomes murder. But the murder, if you fall under any of the exceptions, what will be your status? You will revert back to culpable homicide. That means you will not be punished for murder. You will be punished for culpable homicide. Now, an interesting question comes. Killing is same. Why is there a different punishment for murder and culpable homicide? Of course, we have 3 degrees of murder. Murder of first degree, murder of second degree, murder of third degree, and how law bifurcates it and gives punishment, we will see in the last 2 slides. Okay, for time being, you understand culpable homicide with certain characteristics, that is falling under any clause 1 to 4 of 300, it is murder. If it falls under, your action falls under any of the exceptions under murder, then it is culpable homicide only. That is culpable homicide not amounting to murder. Hope I'm clear. Any doubts, please let me know. Then I'll go with a 300 clause. 300 section. Okay, so I'll take it as a yes, no doubts. Section 300. I told you there are 4 clauses. I'll ask someone to read. I saw one person called as Raju. Is he here? I think he's a newcomer or something. He's not here. B. Raju is here.
Yes, madam.
Yes, sir. Please do read section 300.
Murder, except in the cases hereinafter expected, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death, or secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused, or if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death, or if the person committing the act knows that it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid.
Okay, sir. Thank you so much. So now, by reading this, each and every clause may sound same. Okay, let's try to decipher it into small ingredients so we get a very good idea. Okay, first thing, for murder, there must be culpable homicide. If you see the section, it starts like this. Except in the cases hereinafter, culpable homicide is murder. So it doesn't start with the word act is murder or something like that. It says culpable homicide is a murder. For murder to take place, there must be a culpable homicide. So a culpable homicide will turn into a murder if it falls under any one of these clauses. First clause, that is, you cause the death of the person with the intention of causing death. You heard this somewhere, right? It is nothing but the first limb of 299. So the first limb of culpable homicide is same as the first clause of murder. That's why we say murder is a part of culpable homicide. So let me explain all the ingredients. That is, I'll give you, list out the ingredients, and then let me explain in depth of each and every ingredient. So first clause, you must have caused this culpable homicide with the intention of causing death. Next, you must have the intention of causing a bodily injury, and also you must have the knowledge that the injury that you have given is likely to result in death. So it is not only intention, you must also have a knowledge. What knowledge? Everything we will deal later. Next, you must have the intention to cause a bodily injury, intention only to cause a bodily injury. But it is insufficient in ordinary course of nature to cause death. That is, in reality, automatically, you are intending to give a bodily injury, but this injury is of such a nature that it will automatically result in death. Okay, that is third limb. And finally, you do an action with the knowledge that your action is very, very dangerous, immediately dangerous, that in all probability, it will cause death of a person. And, or see, not only in all probability it cause death, or it will cause an injury which will result in a death. And you do this final act without a lawful justification, then you are committing murder. So I think you have got an idea what it is. If I explain each one in detail, you will completely understand. Okay. So first clause. It talks about first degree murder. That is, first degree murder means it is a very, very grievous offense. The culpability is very high. It simply says that causing death of a person, causing culpable homicide of a person with the intention of causing death. I want to kill the person, I kill the person. How straight it is. So it is the simple and the highest degree of murder. Okay. As I told you, it is the first limb of culpable homicide. That's why we say that murder is a part of culpable homicide. So this is about first limb, and I give you a case law for that. Chahat Khan versus State of Haryana. What happened? The accused took a very sharp weapon and cut the vital part of the victim. Now, how an intention of the accused can be studied? Few cases, the accused itself will come and say that I have done that in order to kill them, or they would have told in the past circumstances, everything. But most of the cases, by the weapon used, what type of weapon he is using, and how he is causing the wound, the nature of the wound caused. These things will tell us the intention of the accused. If you see in this particular case law, he has used a sharp-edged weapon. Usually, why we use a sharp-edged weapon? To cause a very, 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 very harsh wound, right? And that too, he has cut the vital part. You see the injury, nature of the injury. So by this, we know that he has a clear intention to kill, and he has killed. So he squarely falls under the first clause of murder. Okay. Now there is another case law, Vasant versus Maharashtra. In this, two persons, A and B, is having a quarrel in the road, and bystanders come and push them away. They go away. But this person B has a jeep. So he drove the jeep all across in the wrong way and ran over A and caused A to die. Now, if you see the intention here, how he acted, yes, they had a fight, they go away. If he could have gone quietly, right? So he drove in a wrong way and he purposely came and ran over A. Now there is a clear intention that he wanted to cause the death of A, and he has committed murder under clause 1 of section 300. We have an illustration too. Illustration A of this is a statutory illustration. If you shoot a person in point blank, then you have a clear intention to kill the person and you fall under clause 1 of murder. So what is point blank? You shoot the head of the person. Okay. By this injury itself, it's very clear that you want to kill the person. Why I'm giving two case laws for a single clause is that even a single clause can be questioned. So for a particular answer, it will be fulfilled only when you give at least two case laws. So most of the time I get this question, how many case laws to be written for a given UPSC question? It depends upon the question. That would be my answer. Because any question comes on, you write the evolution of basic structure principle. You have to write from Shankari Prasad case law, constitution, right? 6 to 7 case laws. But if a normal question is asked, explain the first clause of murder. When you have the intention of committing death, then only it comes into murder. There you explain the ingredients, then at least give two case laws. One would be the landmark case laws, one would be the recent case law. Recent meaning doesn't give recent death case law, something like that, murder case law. If there is a turning point in the case law, if the case law is very, very crucial, then you can give such a case law. And what should be a conclusion? Conclusion must be way forward. The importance of this section. Like that, you can conclude. Okay. So now let's see the second clause of section 300. You are doing, that is person is causing the death with the intention of causing a bodily injury, and also he has a knowledge that this bodily injury is going to result in the death of the person, is likely to cause the death of the person. So here you need dual mens rea. First one, you have an intention. Here, no intention to cause death. You have an intention to cause a bodily injury only. Okay. But this bodily injury, you are aware. You have the knowledge that this is going to result, likely to result in the death of that person. So knowledge means you know, right? Whose knowledge is that? What satisfaction? We have two things when we are talking about knowledge. Subjective satisfaction and objective satisfaction. Subjective means your own satisfaction. Objective satisfaction means from seeing something, from reality, we understand, right? See, you may perceive that you want to kill some person, but by the actions, others may perceive that you are helping that person. So what others think and what you think is different. So what is asked here in this particular clause is the subjective satisfaction, that is subjective knowledge of that person. So in reality, the injury that he is creating may not result in death, but he thinks that it will result in death. That is totally enough. That's what it means, subjective knowledge. See, why I'm bifurcating is that there is this third clause which talks about objective knowledge. Okay. So let me be more clear by the next slide so you understand. Okay. So by this second clause, first, the accused must have the intention to cause a bodily injury coupled with a subjective knowledge that he must believe this injury is sufficient to cause the death of the person, is likely to cause the death of the person. Let me give you a illustration for that. Okay. Yeah. Illustration 2 will help you a lot. See, I am the accused. I only know that the person is having a particular disease. Okay. That disease, if I give a blow to that person, then this disease will accelerate and kill him. So subjectively, to my knowledge, subjective knowledge, I know that if I give a blow, then this person is going to die. It is not objectively, everybody doesn't know. Let me be very more specific. Say, for example, Mr. A is suffering from a brain tumor. Now, I know that personally. To my knowledge, if I give a blow to him on his head, then this brain tumor will burst and he will die. So if I give a huge punch on his head, usually if someone is punching another person on head, if he is putting a rifle and putting a bullet and all, that person is probably going to die. But punching a person on the head, usually they won't die, right? But I personally know that he's going to die because subjective knowledge is there that he has a disease and it is going to accelerate. Now I'm committing murder. So this is what is called subjective knowledge. Let me go back. And I hope you understood this subjective knowledge. If I explain the third clause too, you will understand even more. Now, the third clause says that you are causing an injury with you are doing a bodily injury, which is sufficient in ordinary course of nature to cause death. So what is your intention? Your intention to cause such a bodily injury that in reality will result in death of the person. What is that? Let me give you a case law for that. State of Rajasthan versus Dhul Singh, the accused has cut the throat of the victim. My intention is to give a bodily injury, this slitting the throat. You know, right? In reality, in objective knowledge, everybody knows that on the face of it, when you see it, you know, you slit the throat, the person will be dead. So although you have only the intention to give a bodily injury, slitting the throat, it in all sufficient in ordinary course of nature, normally in reality, to result in the death of the person. So you are committing murder under the third clause of section 300. Okay. So this is, I hope you understand, you all understand. If anybody doesn't understand, please let me know. Am I too confusing? Let me ask someone whether particularly, Mispa ma'am, like, am I too confusing or able to understand?
Ma'am, could you explain this third and fourth? Like
Fourth,
second and
we
third?
have, second and third. Okay, second and third. Let me come again. Okay.
Ma'am,
Yes, sir.
like if just like in order to remember, the clause 3, we can say that the knowledge is universal. Basically, it's not subjective to a specific person.
Exactly.
Okay, thank you.
Yeah. So, Mispa ma'am, you got the point now.
Ma'am,
It is in
sorry.
reality a universal point. Everybody knows that's what is objective knowledge. But subjective knowledge, what you only know is subjective knowledge. Let me repeat as you asked. So second clause, the accused must have the intention to cause an injury and also a subjective knowledge that he must believe that his injury is likely to result in death of that person. That is the second clause. Third clause, the accused is having an intention to cause a bodily injury, which is sufficient in ordinary course of nature to cause death. That means which is sufficient in the universality. On everybody knows that if this injury is caused, he's going to die. Then clause 3 will apply. Ma'am, you got my point?
Ma'am, but how is it different, ma'am? It's the same thing. Like if he is causing
No.
injury, definitely
See,
no one is going to.
tell me, ma'am. Tell me. Please.
And if at all I'm beating someone in his head, I'll definitely know. Like if the person is injured, there are high chances of him, like getting like him dying. So how is that? Just me knowing and everyone knowing, like how is that different, ma'am?
Because only you know that he has the disease. Others don't know. Okay. Yeah, see, if there is a person who's having a stitch in his abdomen, okay, I am his friend, so I know about the surgery. Others doesn't know. So now what I do is I push this person onto the road immediately after the surgery. He falls down, all the stitches come out, so he dies. So here only I know that he's having the surgery. Others doesn't know, right? So where you can put this person, charge this person, you cannot charge this person in other limbs. This limb will be squarely falling in. You have the intention of causing an injury. You know that, you subjectively know that it is going to cause his death. So how it falls, you understand, ma'am?
Got it, ma'am. Thanks.
Yeah, okay. So we have the final point that is regarding the doing an dangerous act. Okay, let me talk about that here. Yeah, we have another case law for, see, every clause I'm trying to give 2 case laws. So Lakshman Kallu Nikale case, this is, you identify which clause it falls. Okay. The accused has given cut in one side of the chest. Luckily, it is not in the side of heart, but he has given a very deep cut in the other side of the chest. Other side also, you have the other part of the lungs and major veins and all running, right? He has given a very deep cut in such a way, in ordinary time, when he is left unattended, he is going to die. He also passed away. He's dead now. Which clause it will fall? Whether it will fall in clause 2 or clause 3?
Clause 3.
Sir, clause 2, ma'am.
Clause 2, ma'am. Okay, clause 2. Okay. Who are all telling clause 2? Mudasir sir telling clause 2?
No, ma'am. I'm saying clause 3.
Thank you, sir. Okay. So who's clause 2?
Me, ma'am.
Your name,
Sai,
please, sir. Sai, sir. Okay. Litika, ma'am. Okay. Any other? Okay. See, clause 2 says you have an intention of creating an injury and you have a knowledge that it will cause the death. Okay. But this, but you see, specifically you read clause 3 too. It says that you make an injury which is sufficient in ordinary course to cause death. Here, there is no particular knowledge needed. In ordinary course, if you give a very deep wound on your chest anywhere, it is going to cause death. So in reality, universally, we know that it is going to cause death. So it is falling under only clause 3. If you have a subjective knowledge, particularly only you know that clause 2 comes in. You get the point? Okay, am I confusing again? So we will come back again to clause 2 and 3. We will finish up and we'll come back. Okay, thank you, Mudasir sir. So if you could put in other words also, it will be helpful. So after the class, please explain how clause 2
Ma'am,
and clause 3 is different. Yes, sir. If you could
I
do
can
now,
explain.
that will be,
Yeah.
Yes.
Ma'am, the second clause is simply saying that suppose I am the murderer, okay, and I am going to kill Malti ma'am.
Oh,
Then
so good.
sorry, ma'am.
Okay, please do.
Sorry, ma'am.
Okay.
In this case, I have knowledge that Malti ma'am is suffering from a very vital disease in her brain. Okay.
Okay.
Other friends of my class does not know about this, that Malti ma'am has this disease. If I simply blow on the head of Malti ma'am, she will definitely die. This is what I do, and if I commit this, I am falling under clause 2 of 300. This is
Okay.
this is simply different that other friend of my class does not know that you have this, but in clause 3, this is very high chances that if I commit any offense which is in the ordinary course of time, every person would think that his act will cause death, then this will fall under section 300 clause 3.
But ma'am, don't you think in this particular example, everybody also knows that hitting in your head definitely in the course of action will cause death.
Different. See, hitting the head is different. If you're giving a punch on the head, okay. Punch is something different from putting a knife on the head or shooting the person on the head. See, you go give a punch. We give it for our siblings, right? We give a lot of time, punch on the head. Whether he's going to die for that.
No.
Right. That's what we are pointing out.
Okay.
Hope you got the difference. Okay. We'll go to the fourth point.
Madam,
Yes, sir. Yes, sir.
still there are many people think that he will be surviving. Still,
there is no chance of surviving, sir. Only when the person is dead, then culpable homicide and murder will come. So let me read these clauses, sir, so you can get it from even the Bare Act. Secondly, if it is done, that is culpable homicide is done with the intention of causing such bodily injury as far as the offender knows to be likely to cause death of that person. That is clause 2. Clause 3, culpable homicide is done with the intention of causing bodily injury to any person, and the bodily injury is intended to be inflicted insufficient in the ordinary course of nature to cause death. So the thinking of the accused is, knowledge of the accused is totally immaterial here. In third clause, what is seen? Do you have an intention to cause a bodily injury? And whether this bodily injury is of a character that it will result in death, that is enough. But in the second clause, what you need is, first, there must be intention to cause a bodily injury. Plus, there must be a knowledge that this accused has believed that this will result in death. You understand the ingredient now? Hope I'm clear. Mr. Ma'am, I'm clear?
Yes, ma'am.
You got, okay. So still, if you don't get it, you can just disagree. I'll ask Krishnan sir to explain again in next class. So maybe, because see, this is a very, very important topic. If you go without knowing this to the examination, then it will be fatal to your preparation. That's why.
Ma'am?
What is it, sir? Tell me.
Ma'am, is clause 3 of section 300 is exception to mens rea?
No, it is not exception. You see, there is an intention to cause bodily injury.
Ma'am, you have recently pointed out that the knowledge of the accused is immaterial to fall under section.
See,
what
knowledge
this is
only is
indicating?
immaterial. Intention is material. See, first clause, second clause is asking for two things. That's why I pointed out here. Let me tell you. See, here I told you, right? Second clause, you require two type of mens rea. First one, you must have an intention to cause an injury, and also you must have a knowledge that this injury is going to result in your death. So it needs dual satisfaction of mens rea. But here, mere intention is enough. Knowledge is not required. So what is the difference is the criteria only difference. I don't say there is no mens rea needed at all. If there is no mens rea, no culpable homicide itself. Okay, sir?
Got it.
Madam,
Okay.
sorry, ma'am.
Yes, sir.
section 299 first limb and section 300 first limb, how will they be differed, ma'am? They are both
I
same.
told you they are same, sir. That's
Okay.
why we say murder is a part of culpable homicide.
Like how we will be coming in the section 300 if we how we will be differentiated?
Sir, we have lots of points to differentiate culpable homicide and murder. That's what we're having a final slide. I'll
Okay.
put you the slide, this slide, sir. So when we come here, I'll say how first clause is actually same. How others are different, I'll tell you. Why it is same also, I'll tell you, sir.
Sorry, ma'am. Thank you.
No, sir. Please ask doubts. That's what we want. So we have come to the fourth clause. That is, let me take it. Yeah, we have another illustration, okay, for this third clause. You have a sword and you give a lot of wounds to your opponent. Opponent is not, they are not playing and all, okay. You take a sword and give a wound, a club of wounds to the other person, victim, in such a way that in ordinary course, he is going to die. Then you're falling under clause 3, okay. Please, after the class, do read all these illustrations. Now, let me ask you a question. If someone is taking a gun and randomly firing everyone, you don't have an intention to kill particular A or particular B, particular C. You take a gun and randomly shoot everyone. Whether that can be imputed to be a culpable homicide or a murder. Now, that's why we have this clause 4. And this clause 4 have been specifically asked as a question in UPSC. Let me read the question. Section 300 clause 4 of the Indian Penal Code will be applicable in cases where the knowledge of the offender as to the probability of death of a person approximates to practical certainty. Illustrate the above statement. This statement is nothing but the reworded 4th clause of section 300. So let me explain section 300, 4th clause, so you understand the question and we can answer it. 4th clause, you say, you commit an act with the knowledge that your act is imminently dangerous. Imminently dangerous means at the very moment it is dangerous. Okay. And in all probability, this act is going to result in death of the person. Or you have a knowledge that your act is going to result in a bodily injury, which is likely to result in death. And you do all these without a lawful justification, then you fall under clause 4. Don't be worried about how you're going to write the ingredients because it have been retained in this slide. Okay. So first you must do an act. This act must be imminently dangerous, very, very dangerous. The moment you commit the act, it becomes dangerous. That's what it is, imminently dangerous. And also you have the knowledge, that is, you aware that this act in all probability means there is no chance of escaping. There are a lot of chances, say like 99.99% chances that it will result in death of a person. Or at least it will cause a bodily injury that will likely to result in death of a person. Then you are committing murder under clause 4 of section 300. But this is not sufficient. If you're doing all these acts with a lawful justification, then it is not murder. So if you're doing these acts without a lawful justification, then only you are committing murder. Let me give you illustration, statutory illustration, and also another own illustration. Illustration D of section 300 says, one person takes a cannon and immediately turns towards the crowd and shoots them, fires them inside the cannon is blasted inside the crowd. He does that just for fun. Now he knows that he is doing an act. That act is imminently dangerous. He doesn't have a target though. He is putting it onto the crowd. And he knows, he has a knowledge that his act will result probably in all probability that it is going to kill someone. Yet he is doing that just for fun. Then there is no lawful excuse, right? So he falls under the 4th clause and he is committing murder. Let me give you a justifiable example. If there is a mob lynching is coming, like it is coming to your door and it is, you see the mob to be entering everybody's house and they are killing the people there. Okay, so it is coming and knocking your door, pushing everything, and you have a pistol now. You go to the place and you shoot at the mob. Yes, you are doing an imminently dangerous act, which means all probability result in death of a person. But there is a lawful justification. You're doing that only to save you and your family. So it is not falling under clause 4. You are saved. You understand? Okay. Let me give you another UPSC question. Culpable homicide is not murder if it is committed without premeditation in a sudden fight in a heat of passion. Critically examine the statement with leading case laws. So this points out to one of the exceptions to murder. As I told you, under section 300, we have how many clauses? 4 clauses. And we have 4 illustrations. We have completed everything. Now we are jumping to the exceptions part. Okay. Till now, everybody understood? Can we go to the exceptions? Sai sir, understood? Okay. Okay. So Chandrakant sir, I see you newly to this class, I guess, sir. Chandrakant sir, can I hear a word from you? Okay, sir. You understood, sir.
Yes, ma'am.
Okay. Gunjan ma'am have raised her hand. Ma'am, any doubts?
Yes, ma'am. I just wanted to know that without lawful justification, isn't it applicable to every clauses?
See, of course, it is applicable to every clauses. That's why we have justifiable culpable homicide and unjustifiable. But in this clause, it is even more important to specifically point out, because most of the times you see imminently dangerous acts are committed in order to save oneself. That's why law is being more conscious to mark it specifically. Okay.
Okay, ma'am. Okay.
Yeah. So there are 5 exceptions. If at all you are falling under any one of the clauses of murder and also any one of the exception clause, you will not be charged for murder. You will be charged for culpable homicide. So these 5 exceptions are treated only as a mitigating factor, which means totally your fault and guilt is not wiped out. You are not let out free like general exceptions. You are only charged under culpable homicide. Okay. So let's go to the exceptions. Yeah. Before going to the exceptions, let me point out what is the difference in punishment given to culpable homicide and murder. Supposedly, there is a question asked to differentiate this culpable homicide and murder. People will be giving a general introduction. Yes, introduction is very, very important. Most of the introductions, if you are pinpointing the rationales of the question asked, demand of the question, then you will score more. So what is the practical reason for separating culpable homicide and the murder? Is simply because the veracity of the crime they are doing, the mental intent, that has different degrees in culpable homicide and murder. Depending upon this veracity, depending upon the intention it is done, they are bifurcated into 3 degrees of murder: 1st degree murder, 2nd degree murder, and 3rd degree murder. Accordingly, punishment is given. That's why we separate everything. If one person is coming and in a sudden fight kills the other person, that he's talking something bad about the mother and he cannot resist, he gives a punch and he gives a lot of punch that he's dead. And other person plans very well that he doesn't like his brother and he wants all the money of his brother. So kills the brother and sister-in-law and also the daughter, their small child. Now you see the veracity here. In the second event, it is a planned murder for money. The first event you see, it's just a fight, heat of passion. Whether both can be given the same penalty and punishment, death penalty, that cannot be done. That will be injustice. To do justice only, we are differentiating 1st degree, 2nd degree, and 3rd degree murders. Okay, let's see. Culpable homicide is punished under section 304. 304 again is called as part 1 of 304 and part 2 of 304. This first paragraph is considered to be part 1 and the second paragraph is considered to be part 2. So if you commit a culpable homicide not amounting to murder, and if you're doing that without an intention, that is, you're doing that with the intention of causing death or with the intention of such bodily injury, which will result in death, then you can be given a life imprisonment or imprisonment which is running up to 10 years or also fine. Okay. Then you have the second, that is part 2 of 304, which is dealing with culpable homicide not amounting to murder, where you don't have an intention to cause death, but only have a knowledge that your action will likely to result in death. Then you can be given a 10 years of imprisonment, or with a fine, or with both. So if you kill a person without an intention, but you just have a knowledge that you are going to cause death of the person, even a fine can be imputed on you. You see the difference, how much it is given. Depending on the culpability, one can be given imprisonment for life. One can be given only fine also. You see the range. But here it doesn't, for culpable homicide, there it doesn't give the option for the court to give death penalty. So where you can give death penalty? For first degree murders alone, you can give death penalty. That is punishment for murder under section 302. Whoever commits murder shall be punished with death or imprisonment for life and also fine. So let me bifurcate. First degree murder is punished under section 302. And you have the second degree murder, which is culpable homicide not amounting to murder, but with an intention. He has an intention. That is dealt under section 304, part 1. Then you have third degree, that is culpable homicide not amounting to murder without intention, but with knowledge. That is 304, part 2, where you have an option of 10 years imprisonment or even fine or both. Okay. So this is why we are having all these bifurcations. That's my point. So now let's see all the exceptions. See, I told you there are 5 exceptions. The first exception, if you cause murder in grave and sudden provocation, you lose your self-control and cause the death of the person, then you fall under this exception. Provided you don't cause the murder by mistake or an accident. You have a clear intention to cause the death. But you do that death only because you lose the self-control. And this self-control is lost by reason of grave and sudden provocation. What is grave and sudden provocation is very important. We'll see that. But before that, we have to know in what circumstances this exception will not be applicable. If you are voluntarily going and falling into this, getting this sudden and grave provocation, then you are not excused under this exception. Very simple. You very well know if you go to this person's house, he's going to fight with you. He's going to provoke you something and do something bad to you. So you go to his house and you talk rubbish at him. Already he's going to shout at you, and you are talking rubbish at him, and you're voluntarily seeking this grave and sudden provocation, and immediately you use this as an excuse and kill him. Now you will not get the benefit of this exception. One thing. And then if a public servant is exercising his lawful duty and you get provoked by this and you kill him, then you don't get this exception. That is, a public servant, inspector is coming to arrest you. You say, I get provoked because he came and arrested me, so I killed him. It was a grave and sudden provocation. No, it is not justified. No exception for you. Next, in exercise of private defense, the accused is exercising his private defense. Because of that, you get this grave and sudden provocation and kill the accused. Then also exception 1 will not come to your help. Okay. So all this you understand. And then we will see what is, you don't understand, sir?
No, private defense exception.
Yeah, sir.
Exception 1, private defense. How can one be provoked by private defense of any person? An example?
Sure, sir. So very simple. You are coming and giving me a punch. Now, in order to save myself, I'll hold your hand. Maybe I belong to a very lower caste and you are an upper caste person. I'm holding your hand, right? So here you get provoked. How you can hold my hand? You are a lower caste person. How you can touch me and you kill me? So you are provoked by what? You are provoked by my self-defense, right? So you cannot get this exception. Get my point, sir?
Yes, ma'am. Got it.
Okay. Chandrakant sir is having a doubt. Please, sir, let me know.
Ma'am, the cases of celebratory firing which happens in some parts of North India, So will it be considered under 304 or under 299?
Celebratory firing.
Yes, when someone fires a gun and the bullets go into the air and then they fall down with a lot of velocity, such that it
Yeah, it
causes
will
injury.
definitely fall in 4, because see, he in all probability knows that he's doing a dangerous act, and it is going to fall in someone's head if he knows that. See, usually a falling bullet will not hurt others. That's what everybody thinks. But it is of such a nature that it is imminently dangerous, and he knows about that, then he is culpable under that clause 4. That's what it says. Knowledge is important.
Okay. Ma'am, is it charged with section 299 also?
See, 300, when 300 comes, only when 299 is satisfied, 300 comes. That's why we say the section per se. Let me show you the section, so you get convinced. Okay. How the section starts. Let me show you. Murder. See, except in the cases hereinafter expected, culpable homicide is murder. So only when 299 is satisfied, then murder comes. Culpable homicide under the special circumstances become murder. Okay.
Yeah.
So that's why we say culpable homicide is a huge family, which is a genus, and murder is a small part of it, which is a species.
Yes. Yes.
Okay.
Okay.
Sir.
Thank you.
Thank you, sir. So where were we? We were talking about the exceptions. Yeah. We'll go to exception on, we were talking about grave and sudden provocation. What is this grave and sudden provocation? You tell something, you do something that it kindle the violent nature of the accused, and the accused does something unexpected. And he does that because he loses his self-control and someone dies out of it. That's what is called as grave and sudden provocation, which means the provocation must be very, very deep, grave. Just by calling someone to be dark, fat or something. See, if the person is already stressed with a lot of issues, everybody calling her to be dark, fat or something like that, it may be a grave and sudden provocation. So what is grave for everyone depends upon circumstances. But what law sees, the provocation must be very, very deep. That's what is grave. And it must be sudden. It must give out a reflex action. There is no pre-planning. Immediately it kindles him and he does some unexpected action. So these two, grave and sudden, is a cumulative factor. Both must be present. If the provocation is only grave and the person does not act sudden, it will not amount to this exception. Let me give you a landmark case law, KM Nanavati versus State of Maharashtra. Very important case. Anshul sir, tell me, sir.
Just one small question. On the previous slide, it was written that violent nature. So does that mean that the person needs, like, does the person, does anyone need to have a knowledge that that particular person is of violent nature, or does not matter?
Nobody needs to know. Okay. Only the accused must prove that he falls under this exception. Okay. So he must prove that it was so and grave and sudden that it kindled my violent nature.
Okay. Perfect.
Yes, sir. So can I know from which college you are? Like, you are a law student?
Yes, ma'am. OP Jindal University.
Okay, sir. Okay, then. So which state, sir?
I am from New Delhi, but the college is in Sonipat, Haryana.
Okay, sir. So simply I would like to get to know about my students now. So going on with this major case law, KM Nanavati versus Maharashtra. What happened here? The accused was a sailor man. Okay. So he will be on board for 6 months and he will be at home for next 6 months. What happened one fine day when he came home, his wife actually was cheating him with his friend. Okay, husband's friend. So she was feeling very guilty. So she on her own went to the husband and confessed that she was having an illicit affair with his friend. Immediately, this Nanavati was very angry. So, but he did not show. He took the wife and the children and left them in the cinema hall. And then he secretly moved out. He went to the dock of his ship and got a rifle and went to the hotel where the victim was staying and shot him dead. Once the police caught him, he pleaded for grave and sudden provocation. Whether he falls under this category, grave and sudden provocation?
No, ma'am.
No, ma'am.
No, ma'am.
Yeah, you see, court accepted. Yes, it was pre-planned. There is a grave provocation. Somebody, your wife sleeping with someone, it is grave, but there is no sudden action. So grave and sudden must be a cumulative factor. Okay. So next we have another case, Hansa Singh versus Punjab. What happened? The father saw the victim was committing sodomy over the child. Okay, committing sodomy, how heinous is that? Immediately he was provoked and killed the victim. Yeah, sir, tell me.
So in Camp Nanavati, he will be accused for culpable homicide not amounting to murder.
No, why he should be? He doesn't fall under the exception. There is no sudden provocation. He pre-planned everything.
Yeah, ma'am.
So he is committed for murder.
Does not fall under the exception.
Ma'am, if he killed his wife at that point, sorry.
Ma'am, can you repeat, Madhurima, ma'am?
Sorry, ma'am, I was asking if he had killed his wife that point, then it would be sudden.
Exactly. Yes. Immediately you are sleeping with him, one punch and give a poke and shoot. That's all. It is sudden provocation. Exactly. So in Hansa Singh, what happened? The father saw another man committing, that is the victim committing sodomy over his child. So he immediately got provoked. It was a grave and sudden provocation. He killed the victim and it was squarely falling with a exception. Okay. Hope everybody know what is sodomy. It is like an unnatural offense doing with a child. Okay. Almost like rape thing. Okay. Then we have another case, Kandasamy Ramraj versus CBI. What happened here? There was an ex-serviceman, army man, and he was a retired person. He, one fine day, there was few small kids from the slums who jumped inside the cantonment area to pick some mangoes and badam fruits. Okay. He got infuriated by this and he shot a small boy who was below 15 years, I guess, below 10 years, something like that. And the boy was dead. Now he is claiming grave and sudden provocation. Can he be given the benefit of this exception?
No, ma'am.
No, ma'am.
Yeah. In reality, he can never be given. But what the court told, by analyzing his situation, everybody, the workers near him, all the maids and all were interrogated. They told them that this person was a very short-tempered person and he will do everything of a large scale. And one day, there was few kids who broke the windshield of his window. So when someone trespassed again, he was infuriated to such a level and it was a grave and sudden provocation. That's why he killed the small boy. And he was not committed for murder. He was committed for culpable homicide and punished under 304. You see how injustice it is, very bad. But this is what the court told. You can write and give a criticism too, if you would like to. So now let's go to exception 2. If there is a private defense that you are doing an action in lieu of private defense, but you exceed the limit of private defense and you kill the person, then it will not be a murder. It will be culpable homicide, provided you exercise the private defense in good faith. I cannot sleepily, like, I want to kill a person, but I go and plead that I kill the person only for my private defense, but I don't have a good faith. Then I cannot come under this section. So what is the ingredient? You must exercise your private defense. While exercising, you have exceeded the limit of retaliation and you killed the person, but you have done it in a good faith. Then it is only culpable homicide and it is not murder as per exception 2. Okay, let me give you a case law. Nathan versus Madras. What happened? There was this victim family who was owning a lot of land, and this Nathan family, who's the accused family, was a tenant there. So suddenly the landlord comes in and asks for the arrears of the rent and they don't give it. And the landlord forcefully evict the whole family, that is the accused family, the tenant place. Okay. Now the tenant, when they are forcefully evicted, of course, they have a right of private defense to resist it. But he exceeded the right of private defense and gave him a very fatal hittings, blow, spear, everything he used, and he killed the landlord. But the landlord was not having even a small weapon. You see, Although he reacted only when the landlord forcefully trying to evict his family, it is for private defense. He exceeded the limit of private defense because the landlord was totally unarmed. There was no, he did not bring a lot of people to chase them away too. He was the single person who came there. So he exceeded and killed him. Now he falls under, yes, it will be coming under murder, and also he'll be falling under this exception. So he is charged only for this culpable homicide and not for murder. You get the point? Like, because see, these are important. That's why I'm again and again asking whether you understand.
How is the colonel shooting the little boy case is different from this?
It is nowhere different. They must have charged the colonel for murder and given him death penalty, because the colonel very well knows how he must use a weapon. He is an educated person. But you see, every case law, we cannot find justice, right? So this is a classic case law for that. Huge criticism was given all over India. Yeah, tell me, ma'am.
Ma'am, was it the same group of children that had previously attacked something like this?
See, I have no idea about that, but the court gave a justification that these children were usually coming in and trespassing. So he was infuriated. Given his nature, it was a grave and sudden provocation. That's what they have squarely written in 2 paragraphs and concluded. I'll put the judgment too. Okay.
Ma'am?
Yeah. Yes, sir.
In Nathan versus Nadras case, here the tenant exceeded his private defense, not in good faith. Then
yeah.
How?
No, in good faith only. He thought he wanted to stop the landlord, push him outside. But he, in such a way, he wanted to save his family. He used all his things to put him away, and he is dead.
Ma'am, here if landlord is not carrying any type of weapon in his hand, then how can he can exceed his private defense to such extent of causing death?
That's why we call him under culpable homicide. If it squarely falls under the limit of private defense, then he falls under a general exception. He will not be punished at all. See, there is one thing, you exercise the private defense and you are within the limit, then you are saved under general exceptions. There is no offense at all. Okay. Now you don't follow the limit. You come out of the limit, but in good faith. Okay. Then you will be charged for culpable homicide only. But you don't have a good faith at all. Then you will be charged for murder. Now your question you're asking is, the other person is not having a weapon. Now you use a weapon. How you can call it as a good faith? That's the question, right, sir?
Yeah, ma'am. Yeah.
So it was when the landlord asked so much of question and he wants to forcefully pull his wife and push her out and do like, see, anybody who touch the wife and the children and push them out, they will react, right? So that way it was held to be a good faith, in good faith, but exceeded the private defense. Got my point? So the situation was like that. Yeah. You had a good question, sir, but the facts was in such a way that it was in a good faith, but he only exceeded the limit. Something happened there in such a way. Okay, sir. So you have the third exception. If a public servant is discharging an official duty and he exceed the power, provided that he feels that he has that particular power. He feels that, he believes that he is not exceeding. But in reality, he has exceeded his power and he has lawfully done it. He feels he has lawfully done it and he has killed someone. Then he will be falling under exception 3. Let me repeat, a public servant or a person who is authorized by a public servant, he is discharging his official duty. While discharging so, he kills a person in the name of exercising his power. But in reality, he is exceeding the power, but he doesn't know that he is exceeding the power. He believes that he is doing something essentially lawful and he commits the death of the person. Then he will not be charged for murder. He'll be charged for culpable homicide. Let me give you a case law. Daki Singh versus State. He was apprehending a thief. Okay. The victim actually here committed a theft. So he was running away and this constable was apprehending him. And this constable has no authority to shoot him. To shoot a theft person, there is no authority. Okay. Only under certain rules you can shoot the person. So theft person, if they are running away, there is no authority to shoot as per law at that time. But the constable believed that he has complete authority to shoot the person. But he has shot someone else when he is apprehending to shoot the thief. He has shot someone else. Now you see, from the point of view of this public servant, he is doing his official duty and he lawfully believes that shooting is essential and he is lawful. But in fact, in reality, he is exceeding his lawful authority. Now he falls under this exception and he is committing what? Culpable homicide and not murder. So let me, yes, sir.
Ma'am, again, the right question, ma'am. Here, under certain circumstances only shooting is allowed.
Oh, so what are the circumstances? Don't ask me because it depends upon a lot of rules.
Okay.
Yeah.
Okay, ma'am. But the simple principle of criminal liability is that law cannot be excused, like section 76.
Yeah, ignorance of
IPC
law cannot be excused, right?
Ignorance of law cannot be excused. Here, if constable does not know the law, that how he can be.
See, every single small thing, people cannot be expected. But see, I'll give you exact answer for it. That is, ignorance of law is no excuse. But there are, you have a lot of principles and you have exceptions, right? So you have an exception to that principle. That's what legally it has been pointed out in exception 3 of murder. You have very well pointed out. Every principle of law is prone to exceptions. We know that, right? So this is one of such exceptions.
Yes, ma'am.
Yeah. So you can point out in your answer too. So now going with the 4th exception, if you are committing a culpable homicide, it is culpable homicide not amounting to murder. If you don't premedicate, previously plan, and you commit it in a sudden fight, in a heat of passion, and you did not take undue advantage over the victim, and you did not act in a cruel way or in an unusual manner, then you'll be protected under exception 4 and you'll be charged for culpable homicide and not murder. We saw a question, right? Sudden fight. So this is where the question's answer comes in. That is, the culpable homicide will not be murder if it is not premeditated, not pre-planned. First ingredient. Next, the death must be caused in a sudden fight out of heat of passion. And while causing the death, the accused must not have taken an undue advantage over the victim or acted cruel or in an unusual manner. Say, for example, I am fighting with someone. I get so infuriated. So I cut him into some 50 pieces. Whether I can get the exceptions benefit? No, because I am doing an unusually cruel act. So every ingredient must be satisfied. While determining the culpability under this exception, who caused the fight? It is even I may have caused the fight, the other may have caused the fight. So who caused the fight is immaterial. And number of wounds, say he gave me so much wounds, then only I can get a sudden heat of passion and kill him. That straight rule is not there. And when you're talking about sudden fight, definitely it is not a verbal fight. You are having a physical fight, very furious fight. Then only you go for a heat of passion and fight, and then someone is dead. Then it is acceptable. Let me give you a case law. Papu was a state of MP. What happened? There was a guest came to a wedding uninvited. Immediately, few people standing there started to question him. Why did you come inside? Who invited you? How can you come just like that? And he started to argue badly. And he started to give a blow, and other person started to give a blow. And they started a physical fight too. In this fight, the person was killed. Now, this is squarely falling under exception 4. Now, we go to the 5th exception. I have got a chat. No audio. I hope there is audio. Okay. SJ sir, I think Sakshi Jakar, right? Is it Mr. Sakshi Jakar? Sakshi ma'am. You're able to hear me? Okay. Maybe there is problem with her audio. Okay.
Ma'am.
Yes, sir.
Ma'am, in Delhi, we already seen that the people used to beat thief when they caught in the bus or other thing, can that act will also fall under exception 4?
Yeah, heat of sudden fight and all, it will fall. Yes.
Like a mob is killing the thief.
Mob lynching, mob killing, it is different. Okay. But if in heat of passion and the thief, see, catching hold of thief is okay. But if you're hitting the thief, it is again an offense. You understand? But if the thief is, see, he is taking the money and you are infuriated, you hit him, he hit him back, and it is a sudden fight and heat of passion, you kill him, then you will be punished. So they will see in this thief thing that whether there is a sudden fight. Sudden fight means the other person must be ready to fight with you. If he is getting all the hittings and he is standing there, thief is just standing there, it is not sudden fight. You understand? See, there is no pre-medication. Of course, suddenly a thief is got. And there must be a sudden fight, which means the opponent is also kicking you, hitting you. The thief is again hitting all the mob and all. Then there is sudden fight. But if the thief is quiet and everybody keep hitting and hitting, this exception will not come there. Okay. So only very simple point. Every small thing, every small ingredient must be satisfied. Okay. So we go on to the fifth exception. Culpable homicide, that is, a murder will not be culpable homicide if the victim is above 18 years and she has given the consent for causing her death. And this consent must be determined till she is dead, she or he is dead. Okay. Because certain people will say, okay, I'm ready to die with you, or you can cause my death. She will give the acceptance. And when the actual thing or poisoning or something, death is caused, she may revert back and say, don't kill me. Now, this exception will not fall to him. So, if the victim is above 18 years and she gives a consent to cause her death, then this exception will be applicable. The accused will be charged only for culpable homicide and not murder. Let me give you case laws. Masum Ali versus Emperor. What happened here? They were two lovers. They were afraid of separation. So what happened? They planned to kill each other. So the boy actually killed the girl. And when he was trying to commit suicide, he was caught. Now he pleaded that he is protected under this exception because the girl consented. But the girl was below, she was almost only 16 years. So her consent was not valid. He does not fall under this exception. Next, you have another case, Queen versus Antono. In this case, what happened? There were two couples. Both were majors and they lost their children. So in this very deep agony, they planned to kill each other. When the mom was killed by the father, then the father tried to commit suicide. First, the mom was killed. She passed away. And then father committed suicide, tried to commit suicide. The police caught him. Now he was given the benefit of this exception and not charged for murder, but for culpable homicide. See how unfortunate it is. He lost his child, lost his family, and still he's rotting in jail. Okay, so for this we have a famous film, right? Ram Leela. There, I think Ranveer Singh, his name is Ranveer Singh. Okay, I'm not very familiar. And you have Deepika Padukone. At the end of the film, they will try to shoot each other and die, right? Something like that happened here, but unfortunately, Ranveer Singh was saved. Okay, that's what. I'm telling this because you remember the case law. I hope this exception is clear. So we'll move to the differentiation. After differentiation, we'll have a very good session for doubt. Now, what is the basic difference from culpable homicide and murder? Always start with the section. Section 299 defines culpable homicide and section 300 defines murder. And culpable homicide is a very big area. It has a very big scope. That's why we call it as a genus. And murder has a specific area, only the 4 ingredients. If the culpable homicide satisfies, then it falls under murder. So it is a species of culpable homicide. And culpable homicide is of lesser gravity when compared with murder. Murder is more cruel. That's why culpable homicide has a lesser punishment under 304 section, part 1 and 2. And murder has death penalty could be given under 302. Okay. Then we are differentiating clause wise. As I told you, clause 1 of culpable homicide and the murder is one and the same. Why it is given same is that, see, culpable homicide must be there to charge a person for murder. So anyone who falls under the first clause of culpable homicide, automatically they fall under murder. If they fall under the second clause or third clause, they must satisfy any one of the clauses, 4 clauses of murder, and then only they can be charged for murder. You get my point, Sai, sir? You ask me why again it is same, because see, yeah, sir?
Can you repeat once more, ma'am?
Yeah,
Like-
sir. The culpable homicide first clause is same, is the first clause of murder. See, I belong to Hinduism, and I am a Hindu per se, and my name is Malti. So you call me, why Hinduism and my faith is similar? How can you ask that? I belong to Hinduism just because I follow their faith. That's why you see murder is a part of culpable homicide. That's why we say culpable homicide is a huge family and murder is something small in it. So the first clause, if someone falls under the first limb of culpable homicide under section 299, they automatically falls under the first limb of murder. There is no separate proof required for murder. They are automatically charged for murder. If they fall under the second limb and third limb of culpable homicide, then they must come and prove that they form any one part of the 4 clauses of murder, and then only they can be punished for murder. Get my point, sir? Simply saying the first clause of both things are same. Law has intended to make it same because they are nothing different. See, culpable homicide, only 4 things added, they become murder. That's how it is. The root for murder is culpable homicide. That's why there is similarity, sir. Got a little bit, sir?
Okay, ma'am.
No.
Okay, ma'am.
Okay, maybe I'll ask Krishnan sir to explain this in the first part of the next class, so you can understand.
Okay, ma'am. Thank you.
Okay, yeah. Otherwise, I'll come with another example. We can talk later. Okay. So there we'll differentiate the clauses. 299 clause B. I don't say clause B. It is the second limb. Okay. There is no clauses in 299. It is the second limb. You see, there must be an intention to cause a bodily injury, which will likely cause death. And you have the third limb that says you have a knowledge to do an act that is likely to cause death. The likely what we are talking here is a mere probability to cause death. Mere probability means you know that it may result or it may not result. Okay. But here in 300 clause B and C, that is under murder, the intention you cause a bodily injury with the knowledge that it's likely to cause death, or an ordinary sufficient nature that is causing death. These likely what here it is mentioned means it is a certain death. See how judiciary is interpreting. All those same terms used, the likely used in murder is of very heinous. There are more probability, highest probability, almost certain that it will cause death. Then only murder will be attracted. For that, I have a very recent case law. I'll put to you that. Before that, you see the final clause. Under 300 clause 4, you say, anybody do an imminently dangerous act, in all probability it will cause death, then only it is culpable homicide, provided there is no lawful justification. But if you see 299, there is no word called as lawful justification. So 300 final clause is being even more cautious. So that is the final point. Let me explain this likely part. You have a 2021 case law. This is a very important recent case law, because in the case law itself, they would have recorded after a century, like half a century, we are trying to explain the difference between culpable homicide and a murder. They say that there is a very thin difference between culpable homicide and murder. What is the thin difference is the uncertainty part. So the uncertainty in committing culpable homicide is higher, but to cause a person to die without ambiguity, the certainty is very high in the case of murder. Let me read this. The use of the term likely in several places in respect of culpable homicide highlights the element of uncertainty that the act of accused may or may not have killed the person. Section 300 IPC, which defines murder, however, refrains from the use of the term likely, which reveals the absence of ambiguity left on behalf of the accused. So the certainty is only the difference there between these two. So the difference lies in the degree of the act. That's what they have pointed out. Let me give you the facts of this case so you understand. There was a police officer who tried to stop a vehicle, but the person did not stop the vehicle. The driver was lethargic and he drove away a little bit. And the police officer somehow managed to get inside the vehicle and sit somewhere. Okay. But the driver pushed the person down, police officer down. So he got inside the rear wheel of the van and he passed away at the moment. Whether the driver must be charged with murder or culpable homicide, that was the issue. Now the court gone into all the facts and found out, rationally we know, right? If the police officer goes and sits only next to the driver, he'll be able to push him. And also pushing him out of the vehicle, he doesn't know, he may be grievously hurt or something like that. Already the vehicle is moving in a very slow pace. Then only the police officer is able to get inside the vehicle. So pushing him out, he does not have in all probability, and he thinks that the police officer will be dead. So his action is such a way that in certain probability, uncertainly, it is likely to result in death. So he can be charged only for culpable homicide and not for murder. That was the ruling of the Supreme Court. Very simple. If there is an uncertainty in causing death, then it is culpable homicide. If in total certainty the act is going to result in death, then it is murder. So that's what the difference it has been given. Hope this point is clear. Sai sir? You got this point, Sai sir? You're
Yes,
not
ma'am.
here? Okay, sir. So any other doubts? After this, I'll come back to Sai sir to try to explain. Give me an opportunity. Let me see whether I can fulfill. Okay. So any other doubts?
Ma'am?
Yes, sir.
Ma'am, can you please explain illustration 3rd of 300, section 300, 1 second, please?
Okay, sir. Let me. This one, sir. Illustration
no,
D.
Ma'am, 3C, illustration C.
C, okay. We have come to illustration 2. Where is illustration 3? Maybe I did not put it here.
Maybe, ma'am. Sure.
Okay. You have got it from the barrack, sir?
No, ma'am.
Then which one is that? I would have definitely... This one, sir? I have worded both as illustration 2. Okay. This one, sir, you're talking about?
Ma'am, I think the previous one.
Previous
like
one.
Previous slide.
This one.
Yes, ma'am.
Okay, let me read it for you. A intentionally gives Z a sword cut or a club wound sufficient to cause the death of a man in the ordinary course of nature. Now Z dies in consequence here. Then A is guilty of murder, although he may not intended to cause Z's death. So what is the ingredient of clause 3? There must be an intention to cause an injury. So the intention is only to cause an injury. And this injury is of such a nature that it's sufficient to cause the death of the person in ordinary course. So now what the Z has done, Z has given an injury. So his intention is to cause only that injury, not death. Okay. But this injury is of such a nature that it will ordinarily kill a person. See, I'll come and say that I'm going to give a sword cut to you all over your body, that your body is, see, it is sliced here. Something like that, a club wound I am giving you. And I go to court and say that I have intention only to give this injury, club wound. You cannot charge me for murder. I cannot say that. Because this club wound is of such a nature, in ordinary sense, it will cause my death. So simply you have an intention to give this wound, that is totally enough. Although you don't have an intention to cause death. That's what it is, sir.
Okay, ma'am. Yes, ma'am.
Yeah. If you have intention to cause death, which clause will come in, sir? Clause 1 will directly come in. You cause the death of the person with
Yes,
the
ma'am.
intention to cause death. Yeah. Yeah. Okay, sir. So any other doubt?
Ma'am, with respect to the discussion among like the similarity between 299 part 1 and 300 subclause 1. So like in the practicality issue, applicability of it, is it like such in a manner as if like when a person is found to do such an act with the intention to cause death, so automatically that person will now be charged under 300 and not under 299 because the sections are same.
Yeah, sir. Yeah, sir. See, sir, in FIR, if it is written, what the police officer will do is they will be checking what all offenses will be attracting his action, the accused action. So they will give a list of sections. Okay. So they will quote 299, 300, everything. But the court will find out which is correctly, aptly, it is proved. Okay. So if every ingredient of 300 is proved, culpable homicide will not be drawn in. Under 300, he will be convicted. For under 302, okay. For the offense which is compiled under 300, 302 will be the punishment. So 299 will not be taken by the court at all. Will not be written in the judgment. That's what it means, sir.
Okay, ma'am. Even though the first part is like this, exactly the same. That
exactly the
was
same.
just-
Yeah. Yeah. Very well pointed out, sir. Because it may be all those same, but the punishment will be given by quoting only 300 and the punishment under this section 302 that will be given in the judgment.
Okay.
Yeah.
Thank you.
Thank you, sir. Okay. Yeah, sir.
Ma'am, if any murder case will come in the court of law, the court will first, in the first instance, point out whether this is culpable homicide or not. Then he will go for murder.
Exactly, sir. Because without proving culpable homicide, how we can say there is murder? Because culpable homicide under certain exaggerated circumstances only it can become murder. So culpable homicide is like a baby. If it grows only, it becomes a murder. Something like that.
Ma'am, or likely word in both the section 299 and 300 will be the question of fact.
So yes, sir. Because yeah, that's what the court has told there. So likely is how likely it is. So it depends upon the wound given. It depends upon the weapon used. Everything is there.
From case to case.
Yes, sir. Yes, exactly. Hope there is no doubts. Only Sai sir is having a doubt, and I'm sorry I was not able to clear you well last time. Let me try here. I'll tell you, sir. I'll go to the culpable homicide part. See, sir, Sai sir is here.
Yes, ma'am. I am. Yeah, ma'am.
Please put your question, sir. So I'll try to understand again.
I got it, ma'am. What he said. It's a question of fact. I understand that.
Okay.
The court will check it whether it comes under exception or not, and they will charge the section 299 or 300.
Exactly, sir.
Okay, ma'am.
That's what it is. Yeah. Okay.
Can you please repeat section 300 ingredients, ma'am? Part 4.
300 ingredients. Okay, sir. Clause 4. Yeah, sir. To be charged for murder under clause 4, the culpable homicide must be caused by an act with the knowledge that the accused act is imminently dangerous. Imminently dangerous, and also in all probability that his act will cause someone's death. Or at least he is having a knowledge that he is going to create an injury that is likely to cause death. That he is doing all these actions, either like doing an imminently dangerous act or causing an injury, he's doing that without a lawful justification, then he falls under clause 4.
Okay, ma'am. Thank you.
Yes. Yes.
And page 41, ma'am. Can you explain 302 and 304, ma'am?
302, 304. Very simple, sir. 302 is punishment for murder. it gives you an option that court is given an option either to give the accused a death penalty or life imprisonment and also a fine. But 304, it has two parts. First part is dealing with culpable homicide amounting to murder, and you have an intention to cause death. First one. So you will be given life imprisonment, 10 years of imprisonment and fine. And next is 304 part 2, which is dealing with culpable homicide not amounting to murder. You don't have an intention here, but you have a knowledge, awareness that you're going to kill, your action is going to kill the person. Then you cannot be given life imprisonment. You can be given 10 years of imprisonment or even a fine or both. You get the point, sir?
Okay, ma'am.
Yeah,
Okay.
here. Let me read it for you, sir.
304 part 1.
Yeah, part 1 I'll read for you, sir, so you can understand. 1 minute, sir. Let me put a web page, so it will be very, very clear. Give me a minute. You're able to see the screen, sir?
Yes, ma'am.
You see, the offense under 304 have been bifurcated as part 1 and part 2. Part 1 talks about culpable homicide not amounting to murder. Part 2 is also talking about culpable homicide not amounting to murder. But here in the first part, you are doing it with the intention of causing death. Okay, then you can be given life imprisonment or 10 years imprisonment or fine. If you're doing it without an intention, but you have a knowledge that you're causing death, then you'll be given only 10 years of imprisonment or fine or both. You get it now, sir?
Yes, ma'am. Yes.
Yeah, okay.
Both are for not amounting murder.
Not amounting to murder only. Murder means immediately 302 comes in. 302, death penalty.
Okay.
And or life imprisonment. Okay, sir.
Okay.
So I think we have done for today. Any other doubts?
Ma'am,
feel free to ask. Yes, sir. Yeah, ma'am.
Yes, ma'am. Ma'am, please repeat the case of Mohammed Rafiq, the last one case. My internet connection was not very good, so
Okay,
I'm not
okay.
able to get it.
Yeah, I saw, like, initially I was calling you out too, but I was not able to reach you. Okay, what
Yes, ma'am,
happened?
the connection.
Yeah, that case law is a 2021 case law and a recent one. Here it was pointed out that there is a thin difference between culpable homicide and the murder. What is the thin difference? In culpable homicide, there is a mere probability. That is, there is a uncertainty element in causing death. Okay, but in murder, there is a certain element, there is so much of certainty that the action of the accused will result in death. When that certainty is there only, then he will be charged for murder. If his action is so uncertain that it may cause death or it may not cause death, then he will be stopping only with the culpable homicide. Here what happened? A police officer tried to board a vehicle and the driver of the vehicle did not stop. So he continued in a slow pace. So immediately the police officer tried to get in, managed to get in somehow and came to the driver. This driver pushed the police officer down. Now, whether the driver, this police officer fell down and he was taken over by the rear wheel of the van and he passed away at that very moment. Now, the question before the court, whether the driver can be charged for culpable homicide or murder. The court examined everything and told that pushing a person out of a slow-moving vehicle, the accused will not know that certainly he will die. Because it is a slow-moving vehicle. He's just pushing out in such a way that he don't enter the vehicle, that's all. So that was his idea. So there is no certainty of causing death. He doesn't have any certainty of causing his death. So it is only culpable homicide and not murder. So that way it pointed out. This case is very important for difference.
Okay, ma'am.
Okay.
And ma'am, please explain exception 3rd and exception 4 of murder.
Okay, let me just put you the screen so it'll be easy. So internet connection was not well at the time when I was explaining exception 3 of murder. Sakshi ma'am is here. Again, no internet connection.
Yes, ma'am. Yes,
Okay.
yes, ma'am. My internet connection was
Okay.
not good.
Okay.
I guess last 8 or 9 slide, I just completely missed that.
Okay.
I'm not able to get it.
Okay. Exception 3, if a public servant is doing his duty and while discharging his official duty, he's exceeding his power and he causes the death of the person. He believes that he is inside the power, but unfortunately, he's exceeding his power. Okay. In reality, he's exceeding, but he believes that he's not exceeding. Then that will fall under only culpable homicide and it is not murder by this exception. And another 4th one, the final one, right?
Ma'am,
It is
if
about
this
consent.
not come under section 79.
Section 79, what you're asking? Consent you're talking about?
Yes, ma'am.
Exceeding, which one
Ma'am,
you're talking about?
exception 3.
Exception 3.
Exception 3.
Yeah, can you please
Yes, ma'am.
elaborate on it?
Justiciable excused.
No, it is not a justiciable excuse
Ma'am,
because see, lawfully you can do something squarely if it falls under lawful thing. But if it is exceeding your power and you are taking that doing it without knowing that it is exceeding, you won't be protected there. Let me read you exception 3. Okay. It is very clear on exception 3. I did not put the barrack though, but see, lawful justification, you believe in good faith to save someone, it is lawful, everything okay, saving criteria. But you try to harm someone, but you are exceeding the power without knowing it, you cannot be left out. Then it should fall under murder. Okay, then only exception will come in. You have an intention to kill the person and you kill the person. And you fall under the exception, then you commute to culpable homicide. So 79, I think by the ingredients, they won't fall under the ingredients of murder. Get the point, Pam?
Yes, ma'am.
Yeah.
It is not murder. Okay.
Okay. So final thing is about the consent. So if the victim is above 18 years and consented to be killed, then the accused will not be charged for murder. He'll be charged for culpable homicide. That's what is final exception.
Yes, ma'am. Ma'am, exception 4, please.
Exception 4. Yeah, exception 4 is about sudden fight. Okay. If the murder is committed without premedication, but under a sudden fight out of heat of passion, and the accused have not taken an undue advantage over the victim or did not act cruelly or killed the victim in an unusual manner, then he gets the benefit of this exception. He'll be charged only for culpable homicide and not murder. So every ingredient must be fulfilled here. Okay, ma'am. So I think,
okay, ma'am.
Yeah. Okay, ma'am. Thank you so much. We'll wind up for today.
Ma'am, one question. Myself, Raju.
Yes, sir.
Ma'am, can you advise which book I have to refer?
Okay. So you have purchased master course, then you must have the notes with you, right? So
Yes,
how we can proceed is that each and every class, we try to cover what is exactly relevant for UPSC. So if you listen to the class and you take the notes, that is totally enough, because we will be covering the major case laws, recent case laws, CAs, everything. Okay. From where we take everything is from the standard book. Standard book for IPC is PSA Pillai Vibhuti. Okay, you can use that book, the green color cover, right? Hope you have the book. Yeah, you can use that. But if you go there, you will be carried away with a lot of things. If you don't feel sufficient, you can go. But for clearing UPSC with a very good marks for option, just listening to the class and taking notes is totally enough. You go to the previous year question module that we have provided, you'll be able to answer every previous year question. Okay, done.
Okay, thank you, ma'am.
Yeah, if at all you want to go to another reading level, then you can do the revision notes of law experts. We don't do from, if at all
my,
you want.
my question, I mean, query is I have to learn the mode of presentation in the mains, madam, because the language, whatever I understood, I can be presented, but there is things written in the standard books, right? In order to get that sort of format, I mean, presentation of the things and the right vocabulary.
Okay, I get you. That's a good way. Yes, for that you can go to the standard books. So you skip all the unwanted things, whatever I have told in class, try to read that from the standard books.
Same topics, I have to extract those and read the same content from the books and how they are presented on the book. The same thing which we learned in the class.
Yes, you can do that. Very well do that.
The best book is what, may I know the Pillai.
PSA Pillai, edited by Vibhuti. I'll put the front cover of the book.
Can you please, ma'am?
Yes, from the Amazon also I'll put it to you. So you can directly order. Yeah.
Thank you. Thank you so much.
Thank you. So we'll wind up for today. Thank you so much.
Thank you, ma'am.
Okay, thank you.